So we do have with us Christine Marshall from the Border Rights Clinic. Christine has assumed many roles working in immigration and refugee law, including training and public legal education. She has worked in private practice, representing immigrants and refugees in detention work with the Refugee Law Office. And she has taught a variety of people over the years, refugee lawyers, law students, community workers, and immigration consultants. She has worked at Community Legal Education Ontario, developing legal information for refugees and survivors of intimate partner violence, and completed a Master's in Education at OISE in Social Justice Education. She is one of the staff lawyers with the Canada-US Border Rights Clinic, funded by the Law Foundation of Ontario and the McLaughlin Foundation to provide summary legal advice to migrants seeking protection at the border and legal information for advocates working with them. The clinic also offers limited representation in some situations involving wrongful ineligibility findings at the border. She loves baking and riding her bike. So join me in welcoming Christine Marshall. The floor is yours, Christine.
Okay, wonderful. Yes, thanks so much, Onine, for setting up this workshop, and it's really good to be with you all here this morning. Of course, the border is a complicated space with policy and practice these days that can be inconsistently applied by both of our countries. Today, I want to give you an overview of eligibility issues for people seeking protection at the border. I hope that it's helpful to you, and we're always interested in hearing what you're seeing and hearing in your work. We also hope for this session to be engaging, so there's some questions that I'll be asking and some discussion and scenarios. So even though you may be having lunch, I hope that you can join us in those activities. And also, please put your hand up if anything is not clear as we go through. I'm quite comfortable, even though I'm in Toronto and you're mostly in Calgary and surroundings, that let's make this as much like we're in the room together, and you can just stop me if you need to. Great. So yes, just we'll do our welcome. I'll talk about the clinic services, as Onine's already kind of mentioned. Really, we'll be focusing on the key border issue, which is eligibility under the Safe Third Country Agreement, and also eligibility, to make a claim generally. And then we do share some scenarios, as I said, for discussion, different tips. And for sure, the goal is to have room for questions and answer at the end as well. But before we begin, I really would like to share the land acknowledgement that we use in our presentations. So we acknowledge that the work of the Canada-US Border Rights Clinic takes place on the traditional territories of many Indigenous nations across Turtle Island. We recognize that the borders we navigate in our work are colonial constructs that have historically and continuously oppressed Indigenous peoples. These borders have separated families and communities, disrupted traditional ways of life, and imposed systems of control that conflict with Indigenous sovereignty and self-determination. As we strive to support the rights and safety of those seeking protection at the border, we remain mindful of the impact that borders have on Indigenous peoples. We hope to establish relationships that allow us to work in solidarity with Indigenous communities, honoring their enduring presence and traditional land rights. We're grateful to live and work on these lands, and as a virtual clinic, we're committed to reconciliation on the lands where we are each situated. And we, of course, encourage you to do the same. Okay, who we are. As Onine's already said, we're a completely virtual pro bono legal clinic for people seeking safety at the border. We have a host agency called Compass Refugee Center, which is in Kitchener, Ontario. And the Law Foundation was our first funder, and then the McLaughlin Fund has joined us in offering funding in April of this year. Who we are, the clinic coordinator, Jen McIntyre, she worked at Romero House as the director for many years in Toronto, and she also worked at the Center for Refugee Children. She is situated in Halifax. I'm in Toronto, and in April we had Kathleen Hadakel join us, another staff lawyer, and she's situated in Montreal. And then we have a variety of law students and other volunteers. We had a social work student earlier this year, and we've mostly had them in Toronto and Halifax, but we did have a student join us from Buffalo for some period of time as well. And we are grateful for all of their input and work. So what we do, primarily, our main mandate is to give legal information and summary advice for people who are seeking access to Canada's protection system. We have a website that has a section with legal information about the border that's geared towards migrants, and it's in English, Spanish, French, and Haitian Creole. Our summary legal advice is provided virtually, either by phone or video meeting, and we use interpreters as needed. As I mentioned, our mandate extended in April with the funds from the McLaughlin Foundation. So we do provide legal representation for a small number of individuals who have been what we would say wrongly returned at the border. We are available to receive referrals from clients who need legal advice about coming to the border. And we do workshops just like this one. And so what we do is we advise people who are wanting information about whether or not they qualify to enter Canada. So that's eligibility at the border. We do have a lesser number of people who want to know about the interaction between the Canada and US systems. We do not practice US law, but we do have some trusted partners through a Canada-US border network that we can either refer to or ask questions of. And we do also advise people who have been sent back to the US from the border. And in some cases, we can offer representation to try to rectify what we would call wrongful turnbacks. We don't represent clients at refugee hearings, and we don't pass an opinion on the merit of refugee claims. We also don't support clients with their settlement needs once they enter Canada, because there are many amazing organizations across Canada who offer that service. How you can refer clients to us. So clients can self-refer themselves, email, phone, or text. We don't currently have WhatsApp. Or of course, service providers or other lawyers can refer clients by email. And then we do have a referral form. The QR code is on the bottom there. And Onyinye, if you do have that link, then if you could please put it in the chat. And also I will be sharing these slides. Thank you. And that link with Onyinye, and you will get that after this session as well. These are kind of the acronyms that govern the work we do. I'm sure many of them are familiar to you, and I will be expanding upon some of them as we go through these slides. And again, please do stop me if you'd like me to repeat or clarify anything. One small note, I find that with the tensions and anti-immigrant sentiment in the United States, in our media here, sometimes the terminology that the US uses, like asylum seeker, gets mixed into our language. And so, in the US, they call somebody an asylum seeker, whereas our language is refugee claimant. When somebody has been granted protection, that person is either a convention refugee or a protected person, but in the US, they call that person an asylee. Okay. This is a chart that kind of a snapshot of Canada's refugee determination system. And, initially people make a claim. I've put in red the number 2 bubble about the claim being found eligible, because that is a process that I will explain further in its own slide. But once the claim is found eligible, it's referred to the refugee board. It has a hearing. You see the 2 outcomes: a positive decision, the person is a protected person; a negative decision, and they are eligible to appeal the negative decision to either the Refugee Appeal Division or to federal court. In terms of what benefits are available for claimants, entitlement to a work permit while you're waiting for your hearing, and the interim federal health is kind of applicable across the nation, but access to legal aid, social assistance, shelter, and language training are more location dependent. And I assume that is familiar to you. Any questions or comments before we move on? Soon you will be hearing a little more from yourselves, not just me, but I wanted to pause for a second just to see if anybody had anything they'd like to add or ask. And no worries if not, you can eat your lunch and we'll keep going. Okay. So the Safe Third Country Agreement, this is an agreement that our 2 countries signed about 20 years ago in 2004. And this determines which country will assess somebody's claim for protection at the border. The basic premise is that there's a understanding that usually the first country where somebody arrives is the country that should hear their refugee claim. But there are exceptions to this. And the other point is that the basic presumption of this agreement is that both of our countries are safe, as the title suggests, and that the processes and procedures in Canada and the US are kind of equivalent, that they're comparable. Now, this Safe Third Country Agreement has been the subject of 2 legal challenges, one in 2007 and again in 2017. And both times the federal court at the first instance found that the agreement was unconstitutional, that it, in the more recent one, that there was an inhumane conditions of detention in the United States and other procedural inadequacies that offended the Constitution. But unfortunately, as that case went up to the Supreme Court of Canada, the Supreme Court found that the agreement was constitutional. There were kind of technical ways to get around the fact that somebody would be turned back and detained. What some people don't know is that in 2023, when the Supreme Court sent part of that case back to the federal court, it was about the consideration of gender-based persecution. And when the first judge made her decision in 2020, she said, nope, it's unconstitutional based on the conditions of detention. I don't need to look at the equality provision and the fact that the United States does not really consider gender-based persecution. So the Supreme Court said, you have to go back to the federal court to look at that. And as you would imagine, the way the US is treating refugee claims generally, and particularly gender-based claims, there is no date yet back at the federal court, but we are hopeful that the court will take a look at the conditions, and that there may still be room for a positive judgment about the agreement's unconstitutionality. So back to the fact that the basic premise says you should make the claim in the first country where you arrived, but there are exceptions. The most common one is if you have a family member in Canada. And does anybody want to take a guess at what types of family members are eligible to be what's also called an anchor relative? We can put it in the chat if you want. Or you can unmute. Do I see the chat?
So I do see the chat, and some answers that have come in. Someone said parents, children, father, mother, siblings. Then another response, spouse, parents, and then another one, adult children. We have siblings again. Yes, and some mentioned, yeah.
Excellent. Thank you, Oninya. I'm not sure why I'm not seeing the chat, but I appreciate that. And okay, very good. So there's a few more, and then we'll talk about that in a moment. Unaccompanied minor is just what it sounds like, somebody who's under 18 who doesn't have a parent or legal guardian in either country. If somebody has a valid Canadian document, that can also serve as an anchor relative. Or somebody who can come in, they meet an exception. The public interest is interesting, and that one is if somebody is at risk of being sentenced to death in their country. So this is a rarely used one, but it is there as part of the agreement. And then the final one is if somebody is stateless, so there's no country where they're considered a citizen, and they have lived a significant period in the US. So those are the exceptions. Also, it's worth noting that US citizens don't come within the Safe Third Country Agreement. So when the administration was inaugurated in January, we received many, many questions or inquiries from US citizens who might have been trans, individual, or other gender minorities who felt unsafe in the US. So the Safe Third Country Agreement does not apply to a US citizen, and they would not be prevented from making a refugee claim. Whether or not their claim would be accepted and whether or not the argument would be that the US couldn't protect them is kind of a different question. Okay, so this is a little more detail about the family member or the anchor relative. And as you indicated, yes, spouse, including same-sex, including common law partner, although that can be difficult to prove, a parent or a legal guardian with official documentation, a child, a sibling, a grandparent, grandchild, aunt or uncle, niece and nephew. What is missing here on this list is cousin, and we do see many people who have cousins in Canada, and unfortunately, A cousin does not qualify as an anchor. And having a relative in Canada isn't the end of the question, though. You can see from the second column, what their status is in Canada matters. So a citizen, a permanent resident, somebody who's already received protection, somebody who has an approval in principle, so a letter that their application for humanitarian and compassionate for permanent residence on H&C grounds can be an anchor relative. A refugee claimant can be an anchor relative, but they have to be over 18. And that's really important. And it also can't be somebody whose claim was refused or abandoned or withdrawn. Somebody who has a valid work or study permit also has to be an adult. But the work permit can't be somebody whose refugee claim was denied. And the anchor relative, has to be physically present in Canada. So just a little more about the unaccompanied minor. I think we've already said they have to be under 18, no parent or legal guardian in either Canada or the US. And they also can't be married or in a common law relationship. The document holder. So if the person has a document that permits them to enter Canada, that could be a visitor visa, a temporary resident permit, or other Canadian issued travel document, then they could present that at the border and they could make a refugee claim that meets an exception to the safe third country. So the point about the public interest, so this is not that they fear death in their country, which can be more what a refugee claimant could fear or feel. But this is specific to they've either been charged or convicted with an offense that is punishable by the death penalty. So it's a very kind of narrow exception, but if it was something that applied to a client, that would be important. And the stateless exception, this is also less common than the family or anchor relative. And this is somebody who isn't considered a citizen by any state. And then the question of whether or not they have been a habitual resident of the United States, this has to be determined by a factual analysis that, prior to coming to the border, have they been resident in the US for a significant period of time? Any questions up until this point, talking about the exceptions? Okay. So a claim will be found ineligible. The top point there is if they don't meet any of those exceptions we just spoke about, and this is just assessed at the land border. So if they don't meet an exception to the Safe Third Country Agreement, their claim is ineligible. And then the points underneath there are assessed for all refugee claimants, whether they're at the land, airport, or inside Canada. So these claimants, if they made a claim before in Canada, they're ineligible. I will explain in a moment what making a claim in a Five Eyes country means. If they've already been accepted as a convention refugee in a different country, they're not eligible to make a claim here. Or if there's security or criminality issues. So I don't know if I have been following the development of Bill C2, now C12, which is past second reading in Parliament. This proposed law will add 2 more grounds of ineligibility. So people who have entered Canada irregularly, like between official border crossings, and somebody who has been to Canada in the past, they will have a 1-year deadline before they can make a refugee claim. And if this law is passed, these two additional categories of people will only get what's called a pre-removal risk assessment, not a hearing at the refugee board. Now, does somebody want to explain what a pre-removal risk assessment is? Is that something you're familiar with? Is there anything in the chat, Onyinye?
Nothing in the chat, but I did see a thumbs up.
From my understanding, it's just an assessment pre-deportation to see if it's safe for them to be sent back, but something like that.
Yes, yes. Thank you. It's a pre-removal risk assessment, and so it is usually done on paper, and in some circumstances they may have a hearing, but it is regarded as, there are fewer procedural safeguards than there is to have a refugee claim heard at the refugee board. And we'll talk more about the differences between the two things, but thank you for that intervention. Okay, so this you remember before. Oh, okay, Rebecca, you wanted to?
Sorry, I was just wondering, maybe you'll touch on it later, how long that PRA usually takes. And they're not given a work permit during that time, right?
We are, it's a great question, and we are soliciting feedback from people we work with in our network to hear about regional variances in practice and in timelines, because sometimes people do get a work permit while they're waiting for the PRA, and if their removal order can't be enforced, they are legally eligible for a work permit. And, I've heard timelines of a couple of months to 8 months, before people are given the work permit. So we hope to gather more information. And in fact, your colleagues on this call, if anybody wants to share now what your experience is of people who are eligible for a PRA, and whether or not, how long they wait for a work permit and whether or not they get one. We can either talk about that now, or we can talk about it towards the end in the discussion, but I appreciate your raising it. And my sense is there's just a real regional variance. Okay, so this slide, remember I said in that refugee determination slide, there was the number 2 bubble that was about the eligibility decision. So this slide is all about eligibility. So if somebody is coming to the port of entry and they say they want to make a refugee claim, right off the bat, that kind of orange column is a decision about whether or not they meet an exception to the Safe Third Country Agreement. So let's just say on the top row, somebody has a brother here, so they're allowed entry to Canada. If they don't meet any of the exceptions we just talked about, they are sent back to the United States that very same day. If you go to the right of the allowed entry into Canada, then those other points that we talked about are decided. The more what I call general eligibility. So the Safe Third Country exception gets them in, but are they eligible to be referred to the refugee board? That's the top row. Or if they're not eligible to be returned to the refugee board, say they already made a claim in Canada in the past, then they're eligible for a PRA. So this is kind of the flow chart that we're trying to share that talks about how it goes. The other important point is what we call, there really is just a one-time chance to make a refugee claim in Canada. So if somebody was found ineligible in the past, had a claim that was turned down, had a claim that for whatever reason they never went to their hearing or didn't put their paperwork in and it was abandoned, or if they withdrew their claim, all of these categories will be determined ineligible. So it's what we call the one kick at the can to make a refugee claim. And so this is, now I will talk a little bit more to just elaborate on the other reasons why somebody's claim would be found ineligible. So Canada signed an information sharing agreement with these 4 other countries, the US, UK, New Zealand, and Australia. And if at the border, Canada has information that somebody started a claim in one of these countries, and Canada has that information, they will be ineligible to have their claim referred to the refugee board. This was added as a new ineligibility in about 6 years ago. And it isn't just the fact of having made a claim, but that red plus sign is that Canada has to have information through their sharing agreement. Very occasionally, we have had somebody that Canada didn't get the information, but they did actually make a claim in the US. They're not ineligible unless they have written confirmation from the US. And I guess I should say that if somebody is allowed in and later Canada finds out that they made a claim in the US, that eligibility to go to the refugee board can be revisited and taken away. So the other ground of ineligibility is if the person already received refugee status in another country, because you can only get convention refugee status once. That requires a positive decision, and it must be possible to remove the person to that country. Say Sweden accepted somebody as a convention refugee, can they go back to Sweden? This is different from the 5 Eyes ineligibility we just talked about, because that's just starting a refugee claim, not an actual determination that somebody's a refugee. And then the other ground for ineligibility on serious grounds, and this can be a criminal record or allegations of human rights, security violations, or organized criminality. And if somebody is facing this allegation for their ineligibility, then they may need a lawyer who specializes on criminal and immigration law. Okay. So now we get to hear from you a little bit. So Zara made a refugee claim in Norway. She was granted convention refugee status. She flew to the US as a visitor, and she crossed the border into Quebec. She waits 14 days before she makes a claim. How does her previous immigration history affect her eligibility to make a claim? And again, feel free to unmute if you want. Okay, Rafi?
I think because Zahra already granted conversion refugee status, Norway cannot claim in Canada.
Right.
Because
Okay. Very good. Anybody else want to counter Rafi, or do you agree with him?
but can I add
Yeah.
question? Oh, sorry. Let's
No,
go,
no.
Hania.
Is
I would say that's because some of the legal documents that we talked about is that if a person is a visitor, then they could be allowed. And convention refugee status was in Norway, not in the Five Eyes countries, as I understand. So she might be eligible.
Okay. Thank you, honey. What does anybody else think? You want to be a tiebreaker?
I wonder if I mean depending on the details, but if Sarah felt or was somehow, I don't know, discriminated and had basis to claim refuge from a place that had given her refuge. I don't know if that's just getting too deep in detail.
No, basically, the three of you have kind of given the three different ways to look at this. And so basically, Rafi was right that if she's recognized as a convention refugee in Norway, and she can be returned to Norway, then she's ineligible to have her claim heard here. The fact, honey, that Norway is not part of the Five Eyes is a separate consideration, because that's just in the Five Eyes, it's just whether you've started a claim. But if she's actually gone through a hearing and been granted refugee status, that makes her ineligible to make a claim here. But I did once have a client who was alleging risk to go back to the country. It happened to be the Netherlands that had granted him protection. And then he had to make out a case of risk against that country. So that's the additional point. Okay, great. Okay, how about this one? So Zara made the claim in Norway. She left the country before her hearing. She flew to the US as a visitor and again crossed irregularly into Quebec. She waits 14 days before she attempts to make a claim inside Canada. What about her situation? I might be so bold as to ask you, honey, because you were on the right path about Zara before. What do you think now?
I think, I think this is, she would be, let's see, she left the country before she had her hearing. She's not a convention refugee in another country. She flew as a visitor, crossed the border, so I think she will be eligible.
Right. Great. And as the point you said before, she didn't get convention refugee status there. She didn't make a claim in the US, and Norway is not a Five Eyes country. So she would be eligible to have her claim heard in Canada. Okay, so now, okay, Rafi.
Yeah, that's exactly my question. Yes, please. So in this case, Canada government, federal government will contact with Norway to check her file there. If she got the convention refugee in Canada, is still the hearing and process going in Norway, or Canada government will contact with Norway and close her file in Norway?
Well, Canada, Norway is not part of the information sharing agreement with Canada. It's only the US, UK, New Zealand, and Australia. But you're right, Rafi, in saying that if the refugee board can get information from Norway about what she said in that claim, it doesn't affect her eligibility, but it may affect determination of her claim if she said something else than what she's saying now.
Okay, thank you.
Yeah. Okay, great.
May I ask a question, if you don't mind me?
Of course.
This is Honey, by the way.
Okay.
You said that Canada should have, like, if somebody is coming not from the Five Eyes countries, Canada should have an information like a piece of information that says this person is a convention refugee in another country, right?
Right.
If they don't have this kind of document or this kind of information, even if the client was a convention refugee in another country, it won't matter.
Well, in the basis of claim form, they are asked specifically, have you made a claim in a different country and have you been accepted as a convention refugee? And so if they don't answer that truthfully, that could be a problem for misrepresentation or vacation to take away their status after. I'm not sure if I capture your question exactly.
No, I understand. Thank you very much.
And you know, if the client herself has the documents that she submitted in Norway, she can put them in to kind of show that she's consistent. If the minister tries to get it, whether or not they'll wait for her hearing, although these days hearings take so long, but they are capable of doing that in kind of a credibility hunt on clients to see if they can find something that's not consistent or accurate. Okay, great. Then we have our last scenario. Zara never went to Norway, but she did go to the US and she made a claim there. She left before her US hearing and same thing, came into Quebec, waited 14 days and tried to make a claim inside Canada. What is going to happen in this third scenario? How about somebody I haven't heard from yet?
So Mariam placed a comment in the chat. She said she would be ineligible as she started a claim in a Five Eyes country.
That's right, exactly. And if Canada has proof of that, so you're absolutely right, and most likely they will, but very occasionally they don't have the proof, but I would never count on that in advising somebody whether or not to come to the border. Yes, okay, great. So,
Can I ask a question, please?
Of course.
In all three scenarios, I noticed that you stated Zara waited 14 days before making that claim. Is there a significance to that?
Yes, and absolutely there is. And I'm just about to talk about it. Basically, the next slide will help me talk about that. Okay, thanks, Onyinye.
Would she be asked to, or would she apply for a PRA?
Yes.
Okay.
Potentially. But remember, she needs to cross that safe third country exception threshold even before she is determined whether or not her claim is eligible to get a PRA, right? But anyway, you're on it, and we're gonna unpack these things a little more. But okay, what we call the 14-day rule is, you nabbed it, Onyinye, that the safe third country applies all the way across the land border. So you may be familiar with Roxham Road. This was an unofficial port of entry in Quebec that prior to March 2023, people were coming, just walking across the border. The Canada and the US signed what's called an additional protocol in March 2023 that meant no more unofficial crossing into the border, that the safe third country applies all the way across the land border. When they signed that additional protocol, they also added a provision to the law that said the safe third country does not apply if somebody enters Canada and is here for 14 days. So on the left here, we have where it applies. So it applies all the way across the land border, and it applies from kind of day 0 all the way up to day 14. if somebody's going to come irregularly across the border. When it doesn't apply is at an airport or a seaport, or if somebody has come irregularly across the border after 14 days, then the safe third country doesn't apply to them anymore. So that is important. It was something that was added to the law when something else was taken away. And what is important also is that if somebody, they may be apprehended, on the day they try to cross. You've all heard stories of people who cross in terrible wintry conditions and are nabbed by the RCMP or CBSA right as they cross. Or if they're detected in those first 2 weeks. But if they make it to day 14, the safe third country doesn't apply. And when they make their refugee claim, it's important that they include some proof that they have been present in Canada. And that can be a phone card, a letter from a shelter. It can be a bank machine transaction, just that they could prove it. And I remember being at a conference a little while ago where somebody misunderstood the rule and made their refugee claim on day 13. And very unfortunately, the Safe Third Country Agreement applied to them and they were not eligible to make a claim. Okay. So what, and I can throw this out to you just because we're getting tired of the sound of my voice. What is the consequence of being found ineligible under the Safe Third Country Agreement? So this is kind of what I refer to as the threshold issue. You're at the border, and whether or not you meet an exception, what happens? Or what do you think happens?
Okay, so Nogabi says they cannot go for refugee claimant status.
That's right.
Right.
And what else?
They have to do a PRA.
Well, okay, that's a good guess, but if they don't meet an exception under the Safe Third Country Agreement, they don't even get to the PRA stage. So remember this little graphic. So there's an eligibility interview, and the first thing is, do you meet an exception? The top row, yes, they're allowed in. The bottom row, no, they are sent back to the US that same day. CBSA will not go on to consider what I call general eligibility, which is those green bubbles to the right of the entry. And so if they're found ineligible under the Safe Third Country Agreement, they get an exclusion order right there and then at the border. And if they're ineligible because of the Safe Third Country Agreement, their exclusion order can be executed that very same day. So if they're ineligible for a different reason, then the exclusion order can take effect in 7 days. But the Safe Third Country ineligibility is really, this is why we were so disappointed with the Supreme Court about the legal challenge. The Supreme Court came to this very kind of academic administrative law thinking that people at the border had access to something called safety valves. You could make an H&C at the border. You could ask for a temporary resident permit. None of that is kind of practically available to people at the border when they can be returned back that same very day. Not only access to legal counsel or language, it's very impractical and almost impossible unless you have a legal team ready and waiting and prepared to go. So the other thing about the exclusion order is that usually a person can't return for 1 year. In some cases, the person may be able to come back to Canada despite this 1 year exclusion order. And that's if they now can prove that they meet an exception to the Safe Third Country Agreement. That they may have new evidence of a relationship. I know my colleague Jen had an unaccompanied minor who CBSA investigates to see where the parent or the legal guardians are. The boy's father was leaving Canada, or leaving the States, sorry, but he answered his phone at the airport. So technically, that child still had a parent in one of the countries. Once that father was confirmed departed from the US, then the child was legally considered an unaccompanied minor. But he already had the exclusion order, so he would be eligible for a PRA. Sometimes you'll see situations where somebody is just a PRA applicant. That is not an eligible anchor, but if their PRA, pre-removal risk assessment, is accepted, then they're a protected person and they can be an anchor. And then the final situation is also if somebody comes to the border, they're sent back because they say you don't meet an exception to the Safe Third Country Agreement. They wait 14 days and they come back over the border. No, sorry, they don't wait 14 days. They are sent back to the US. They are excluded. They come back across the border irregularly inside Canada after 14 days. The Safe Third Country Agreement does not apply to them, and they can't be removed from Canada without getting access to a PRA. I'm going to stop here for a minute too, just to see if anybody has any. I have about 10 more slides, just in terms of questions. Josue, if I'm saying that right, Josue?
Josue, yeah, thank you very much. I have a question. Can you make a comment about the situation of Venezuelans in the U.S. Right now? I'm talking about the people who hold a TPS status, but they have been revoked by the American government. If they come to Canada, because Venezuela is not a safe country to go, would there be exceptions for them? Because I mean, they cannot stay in the U.S. because the status was revoked by the government.
Yeah.
It was, as you know, an administrative measure that the previous government issued. Actually, the first government of Trump was the one who issued the first TPS status. So can you make a comment about it, please? Thank you.
Yes, no, and thank you for the question, Josue. It is a really challenging aspect of our work that people who are very fearful with the cancellation of temporary protected status, Venezuelans, Haitians, Nicaraguans, Hondurans, many people are in this category, and you would think that Canada is not removing anybody to Venezuela. That shows that Canada recognizes that it, as you say, is not a safe country. Unfortunately, that is not enough reason for those Venezuelans to come to the border to seek protection in Canada. They still need to meet an exception under the Safe Third Country Agreement, so have a family member here. And I'm going to talk in a few later slides about how that looks on paper. Does that? So bear with me, and then we can talk again as I talk a little bit more about it in the future. Is that okay, Josue?
Yeah, yes, sure.
Okay.
Thank you very much.
Okay. I see another question. Oh, Anna, yeah. Or I don't know
Anna,
if you're
your microphone is muted.
Yeah.
If you're unable to unmute, you can also use the chat and I will highlight the question.
Right.
Kristen, I think we can proceed, and once the question comes in, I'll let you know.
Okay, sure. That sounds good. So these are some of the challenges that we see at the border in our work. People who they approach the border without getting a legal opinion about their eligibility. So just because I talked about all those exceptions to the Safe Third Country Agreement, you really need to be careful about what proof you have to demonstrate either your family relationship or other exceptions like statelessness. We are seeing that Canada Border Services agencies are really scrutinizing documents very carefully. And despite anchor relatives being present at the border, waiting to meet their relative, CBSA does not always interview them because they could help corroborate the relationship. People also get their phones seized by CBSA. So we always tell people to print out, or obviously to bring the originals of their proof. But if they have other proof, don't bring it electronically on your phone because your phone will be taken away in most cases. Sometimes they don't know what the concerns of the officer are. Once somebody has been given an exclusion order, they don't always get given the written refusal or the notes that the officer based their decision on. Really, unfortunately, since this new administration, people who are turned back to the US because they don't meet an exception to the Safe Third Country Agreement have a greater likelihood of being detained in the US and then ultimately removed either to their country or a third country. So we really try to get this word out to get a legal opinion, to get an analysis of your documentation before you come to the border. And as I will elaborate in a minute, family separation is also probably the most devastating part of our job, that we will advise individuals, and some of them could be permitted to come in, but this requires very painful decisions to be made, that some can get in and some cannot. And, do they proceed? So I guess just on that point, that we do see people coming where their anchor relative was not aware they were coming. This is really important, that they should not only be aware and available for a phone call, but I suggest be present at the border. Sometimes they get poor advice. Sometimes it's over a long weekend. CBSA doesn't wait for them to get extra proof. And we've also seen them question the claimant based on information in their relatives' IRCC file. And this is kind of challenging. You might have a brother, but you might be 15 years age difference, and you don't know the intimate details of his work and residence history. Okay, Onyinye, was that Anna's question now is ready?
Yes.
Okay.
So Anna's asking, are Ukrainians who resided in the USA under the U4U visa and whose status was not extended are they eligible to come to Canada and claim refugee status at the border?
So it's a good question, Anna. And I don't know about that program specifically, but they would need to meet the same eligibility that initially it's, do you meet an exception to the Safe Third Country Agreement? And then are you eligible to make a claim? So I'm not aware of any additional program for eligibility, but I think the same rules that I've been showing on these slides would apply to them in that situation as well. But unfortunately, the details of that program are beyond the mandate of our clinic. Thank you for reading it, Oninye. Okay, so this is a lot of what we see. When you have families coming together to the border, so here we have a mom, a spouse, and a child. So the mom has a aunt who's a Canadian citizen. How it goes is CBSA will determine mom's claim first. She'll look at the proof of mom's birth certificate, aunt's birth certificate, confirm the familial relationship. And then once they're satisfied that this is truly her aunt and she's a citizen, then the mom can be an anchor relative for her spouse and child. And that's because people would ask me, do we need to have mom go to the border first and be let in and be found eligible, and then dad and child would follow? And no, CBSA realizes that families come together and they will process and look at the documents of the person who is asserting that they have an anchor. So here's another question for you. Maria has been living in the US without status for 6 months. She wants to make a claim at the border because she has an uncle in Thunder Bay that she can live with. What information do you need from Maria to determine if she's eligible under the Safe Third to make a claim at the border? There's a few things you'd want to ask Maria, but you can unmute and just say one of them. You don't need all of them. Yeah.
Maybe she needs to prove relationship with
Yes.
the relative.
Yep. Yep.
She needs to prove that she never claimed refugee on the United States to be eligible. Mm-hmm.
Yes. Very good. And there's one third one.
And she needs to prove why she needs to be taken as a refugee. She needs to have a motive for that. Or
That's a great point. In the eligibility assessment, they're really looking at, are you eligible under the Safe Third, and are you eligible generally, like the US claim? The CBSA are not supposed to get into big detailed questions about your refugee claim or your fear. So there's one other question that Maria, if I were meeting with Maria, I would need to explore with her. Yeah, Anna?
She is not convention refugee in any other countries besides like 5 ICE countries?
You do want to confirm that, yes.
Mm-hmm.
That's a good point. Okay, that's a fourth one. So I'm still waiting for one other thing. Olfa?
Status, a confirmation that she doesn't have a status in USA. So she doesn't have any residency in USA. Maybe.
Well, is that an obstacle for her though? What if she was a US citizen? I mean, if she was a citizen, she wouldn't have an obstacle, but you're getting warmer. It's not so much Maria's status. Who else's status do we need to explore?
Oh, the relative that she has in Canada.
That's right. What is uncle's status? Absolutely. Okay. And also, is he in Canada? Good. Okay. And here we have another one. So Abed fled Afghanistan to Brazil and traveled to the US on foot. He entered the US irregularly. He doesn't feel safe there and wants to come to Canada, where he has a half sister in North Bay who's a permanent resident. Neither Abed nor his sister have birth certificates because they were both born at home. The Afghan government is not producing new birth certificates. How do you think they can prove their relationship to CBSA? What are some of your ideas?
Maybe a notarized document from someone that prove that they can give faith that they are related or something like that, and signed by a notary.
Yes. Okay. A notarized or a sworn statement
Mhm.
from somebody who might be related to or certainly knows them or knew them in Afghanistan. Great point. What else?
I'm thinking perhaps school records from growing up or anything like that that shows
Yes.
they're from the same family.
Yes. Yep. School reports that show you they're
Yes.
went to the same school. What's another thing that would show something about growing up? Photos. If they have family photos too. Uh-huh.
And even DNA records, like now this is more common. Yeah.
Yes, yep, we do and have had to resort to DNA, which is costly and not accessible to everybody, but where there's nothing else, no documents, very little proof, DNA can help. Or if the proof that you have is kind of contradictory. You may have, I had a client who had both French and Congolese spelling in their documents, and the very zealous officer rejected it rather than, speaking to the anchor, but DNA helped settle that. So yeah, any other documents that lists the parents' affidavits, letters of support from other family. Look at the half-sister's application for PR. That can help. Did she list her brother? DNA, there are specific rules that have to follow. It has to be an IRCC accredited testing company, and we do give tips about doing that. Also proof that, it's common to not have a birth certificate when it's a home birth. And we would also prepare the brother and sister for questions that CBSA might ask them. Was there another hand? Yeah.
I was just wondering if Abbott didn't have a relative, then would they even accept a claim?
No.
No.
Remember, if he doesn't meet an exception to the Safe Third Country Agreement, unless he comes irregularly across the border by foot, there's that threshold eligibility. Do you meet an exception or not? If it's no, you are going back to the US. Despite, as Josue was saying, Afghanistan is another country that Canada does not remove people to. Okay. So this is exactly your question. So if Abed did not have a relative, this is what is assessed first. And if he is ineligible, you don't even get to the general eligibility consideration, which is these other points. Okay, what if someone is allowed to enter under the Safe Third, but is ineligible for a different reason? So this is the person who does have a brother, but say they made a claim in the US. Yeah.
I think they will go for a pro.
Okay. Yep. Great. So this is just doing this picture again. So their eligibility interview, They do have the brothers, so I'm trying to capture this with the green bubbles. That's a green light. They're allowed in, but they're not eligible because, say, they made a claim in the US. So the ineligible bubble brings you to a PRA. So if we were in the room, honey, I would throw you a candy and say, yep, you got it. But I don't. Okay. And so we talked about this briefly earlier. This chart kind of looks at the difference between the refugee hearing, which is an independent board member, and it has more options if refused. For someone who is ineligible to go to the refugee board, they get the PRA and they either get an interview or they just have a paper-based application. It's not an independent trained board member, it's an IRCC officer. The legal test and the legal outcome are the same to be a protected person, but what we call the procedural guardrails are very different. And the PRA refusal only can go to federal court, whereas the rejected claimant can go to the Refugee Appeal Division, federal court, and possibly the PRA in some circumstances. The thing about more people with this Bill C-12 will be put over to the PRA. So all those people we talked about who kind of tiptoed across the border and waited their 14 days, they're automatically PRA. It doesn't matter if they never made a claim in the States or Canada or anywhere. It's like a kind of a punishment that you're going to get the lesser kind of protection mechanism. So there will be long delays, maybe lack of access to legal aid, month-long wait for work permits, which is back to your original question, I think, Rebecca. People may not have representation. Basically, we're shifting from a protection to kind of an enforcement-driven system. And this will, moving more people to the PRA will mean more files at the federal court, which is actually more expensive and therefore less efficient. And that could create a crisis at the court. Okay, we have 10 more minutes. We just have a few more scenarios. So Amina enters the US on a student visa. She makes a claim at the border because she has a sister living in Winnipeg who has applied for PRA. Amina is given an exclusion order and turned back to the US. 10 months later, her sister's PRA is accepted. Why was she given an exclusion order the first time? And what do you think will happen if she comes back to the border to make another refugee claim before 1 year? No, Gabby?
So I think she was declined because at the time that she tried to enter, the sister still didn't have a PRA. Yeah?
Absolutely,
So
yes.
the relative, that is the anchor, didn't have an status, a proper status in Canada at that moment. And I believe now that the sister has a PRA accepted, she might try again.
Yes, perfect. A PRA applicant is not an eligible status, but a protected person is. Okay, very good. So this is the scenario I just talked about, how this is the same family at the border and there's no US claim. So it's the anchor chain. Mom can prove her relationship to aunt, and then mom can be the anchor for partner and child. In the situation where they did start a claim, this is the tragic part of our work, mom can prove that she has the aunt and she can come into Canada, but she only gets a PRA because the 5 I's ineligibility, she made a claim in the States, She doesn't get to go to the refugee board. So she, like that situation we just thought of with Amina, she is only a PRA applicant. So mom will be separated from partner and child. She can't be an anchor unless and until her PRA is accepted. Okay. So can you think of any reason where somebody who did that flow chart, they meet an exception to the safe third, they don't get to go to the refugee board, they do get to make a PRA, but for any reason they aren't able to apply for a PRA? This is kind of a tricky question. If their removal order can't be enforced because they're from a country that doesn't remove people to. So this is your question, Josue, and Venezuela, Afghanistan, Haiti, Cuba. These are countries that Canada does not remove people to. They are either called administrative deferral of removal or a temporary suspension of removal. What it looks like in practice is this same scenario where mom could come in to get a PRA because of her aunt. The partner and child can't because mom is just eligible for a PRA. And the heartbreaking situation is mom will not be served with a PRA because she is not pre-removal. So the PRA, you remember, is a pre-removal risk assessment. So mom only gets to come into Canada. She is protected from being removed from Canada, but she can't move forward. She is in legal limbo. She does not get the PRA that would give her protected person status. She has to wait in Canada. The result is that she will be separated from her partner and child for a long time. Eventually, if she, gets a job and gets language training, she can apply for permanent residence on humanitarian and compassionate grounds. I think you may have heard of H&C applications, but the devastating news we've heard this month is unbelievably, the government has recently announced that it could take 10 or more years to get an answer on an application for an H&C. So these are impossible decisions that family members are making, and it is gobsmacking or just heartbreaking, absolutely. Okay, let's look at one more question and then we'll have a few minutes for discussion. Abdul, Fatima, and their 2 children have made claims in the US. They are from Afghanistan. They decide to leave the US and go to Canada because they fear detention and removal if their claims aren't accepted there. She has an uncle in Saskatoon who's a citizen. What will happen if the family approaches the border to claim protection? So they're ineligible because of 5 eyes. Fatima could enter if she can prove her relationship to her uncle, but because of the 5 eyes, she only gets the PRA. This is kind of a human demonstration of the situation that she will be stuck. She can join uncle and be safe in Canada, but she can't move forward because she won't be served with the PRA. Abdul and the children can't enter because Fatima can't be their anchor, as somebody who's only eligible for PRA. And unless Abdul and the kids make the dangerous, attempt to cross the border to join Fatima and wait 14 days, this family is going to be separated for a long time. And we can't give legal advice. That is the law on the books. But because technically that is a breach of the Immigration and Refugee Protection Act, we can give people information, but we can't give them advice about doing that. And I'm sorry I've used almost all of our time, but I will just conclude with saying, the tips, we really emphasize that it's so much better for somebody to get advice and analysis of their situation and their documents, because the consequences are so high these days of family separation, return to the US, or detention. Sometimes people have heard information that is incorrect, so it's important for us to give them the correct information, and just to emphasize that they really should get advice before they try, because trying to correct somebody being sent back after is a lot more challenging. So if somebody has been turned back, the options are ask CBSA to reconsider their decision, usually with new evidence. It is possible to ask the US authorities that they can ask Canada to reconsider. I do know of colleagues for whom this has been successful, but I did it once and it was not successful. They just said CBSA should do that. It is possible to go to federal court to challenge the refusal. And it's also possible to make a second approach with more evidence. And in that case, the person could be eligible for PRA because they've already been turned back once. And this is our contact for questions. I appreciate the work that you all do. I'm grateful to you, Onyinye. I have still, I'm happy to answer a few questions if the remaining moments, if people want to stay on for another couple of moments. We have gone right to the wire, but okay, I see. Yeah, Norgabi?
Okay. Yeah, regarding the people under APRA, I noticed that one of the challenging things for them is to obtain a work permit.
Right.
And they feel like in a limbo because they say, okay, we are here, but we need to provide for our family, but we cannot work because we don't have a work permit, and they cannot find the right support to get that work permit.
Yeah.
Is there any recommendation or something that you can add to it?
It's not getting the work permit, and it's also not getting the refugee protection ID too, because that opens access to interim
To the
federal
work permit.
health. And I mean, I think sometimes it involves going to the person's member of parliament and advocating for them to look into it. What is the delay here? Writing letters. But I'm open to other suggestions, and I know we are going to the Canadian Council for Refugees Falls consultation in Winnipeg in November, where we are going to compile people's answer about that. But if they are here and their removal order cannot be enforced before they are given a PRA, they are entitled to a work permit. But the delay, those are, I don't know if others have other examples of success they've had, but I do recommend people go to their member of parliament or also your agencies, to write a letter to ask and say, it was June 2025 that my client applied for a work permit. It's been 4.5 months, you know, when is it going to come?
Thank you.
Okay.
We have one more question that didn't get answered in the chat. If a PRA is approved, do they automatically become protected persons, or would they get a hearing?
Okay, great question. If a PRA is approved, that is a protected person. And they then can apply for permanent residence as a protected person, but they could serve as an anchor relative for their family members. There are situations that are more complicated than what we could talk about here. If somebody fit that kind of serious criminality or human rights violations, and they were at risk to go back to their country, they get what's called a restricted PRA, and those people don't have full protection. But the majority of PRA applicants, in the regular sense of the word, when they are accepted, they don't need to have a hearing. They are a protected person. The people who get a PRA because they were ineligible, because they made a claim in the US, those are entitled to a hearing before an immigration officer. It's more like an interview. And at the end of that, if they are given protected status, then it's over. I mean, it's successful, not over, in a good way. Okay.
I got that.
Yeah.
Thank you so much. I don't see any more questions, rather lots of thank yous from attendees, especially those who had to drop off.
Okay.
So to those who stayed, thank you so much for your, giving us some of your time. And thank you so much, Christine. This has been so amazing and very engaging. Thank you so much.
My total pleasure. And thank you, Onyinye, and everybody for your contributions and questions. So take care. I will follow up with the slides, and thanks for coming, everybody.
Thank you.
Thank
Thank
you
you.
all.
Okay. Bye-bye.
Bye now.